Attorney, you now represent the petitioner. Do you wish to make an opening statement?
Your Honor, Mr. Mathis and I spoke. If you've read our briefs, then we're just going to start with the proof, if that's okay.
All right, let's go ahead then, and we'll start with the proof. You may call your first witness.
Judge, with your permission, I'm gonna sit over there in the jury box.
Sure.
Can't hear anything, dude, so.
Wherever you're most comfortable and you can see and hear.
Thank you, Judge.
And I would call Benjamin Lewis Keel. Truth, nothing but the truth, so help you God.
I do.
You've been called as an adverse witness, so I'll ask you to speak loudly into the microphone, please.
Yes, Your Honor.
You are Benjamin Lewis Keel, is that correct?
Yes, ma'am.
And you and Miss Coley Pritchett, who's seated here at council table, were divorced on January 28th of 2016, is that right?
Yes, ma'am.
And as a part of that divorce, you and she had one child, Kinsley Brooke Keel, is that right?
Yes, ma'am.
What's Kinsley's date of birth?
August 21st, 2013.
And how old is she today? I'm sorry?
8.
And at the time of the divorce, in 2016, she was how old?
3.
I'm going to pass forward to you, Mr. Keel, a copy of the court-ordered parenting plan for you to have for the benefit of the child. Do you have that there before you?
Yes, ma'am.
Do you recognize that document as your court-ordered parenting plan as of January 28th of 2016?
Yes, ma'am.
All right, and under the day-to-day schedule there, it says the father shall enjoy parenting time with the child once he is out of the military 2 days per week on his days off, and if the father has 3 days per week, and if the father has 3 days per week, he shall enjoy parenting time for those 3 days on every other week. Exchange time shall be agreed upon by the parties, text no later than 48 hours in advance. Is that right?
Yes, ma'am.
Okay. And then in addition to that, you had every Father's Day. Is that correct?
Yes, ma'am.
You had shared Halloween time. Is that right?
Yes, ma'am.
You had Thanksgiving time in odd years and in even years at different times. Is that right?
Yes, ma'am.
You had shared times for the child's birthday, which was August 21st of 2013, odd years from 10 to 3, even years from 3 to 8. Is that right?
Yes, ma'am.
You had Christmas vacation, which had you in odd years. You had from the time from 24th to the 25th, and then in even years, 25th to the 26th. Is that right?
Yes, ma'am.
And then it talked about transportation arrangements on page 3, which talked about a meeting place for to exchange the child. Is that correct? Under transportation, it's subsection number H.
Yes, ma'am.
Okay. Now, those visitations that you were awarded on January 28th of 2016, you did not exercise any of those up until Christmas of 2016. Is that correct?
No, ma'am.
Okay. When in 2016 would you say that you visited with the child other than Christmas of 2016?
Her birthday?
And her birthday was August 21st. And when did you visit with her in August of 21st of 2016?
At her birthday party?
So you came in for a birthday party in August. How long were you there?
30, 45 minutes.
And aside from that and a 35-minute visitation on Christmas of 2016, that's the extent of the contact you had with this child in 2016 face-to-face, correct?
Yes, ma'am.
Okay. And you did not have any phone contact with Miss Coley Pritchett in 2016 to speak with the child, did you?
No, ma'am.
Okay. Now, in 2017, you didn't have any face-to-face contact with the child, correct?
I showed up to every birthday until 2019.
Okay, so you think you were here in 2017 for a birthday visit like the one you testified about in 2016?
Yes, ma'am.
Okay. In 2017, you were actually in town for Christmas, but you didn't visit with the child in Christmas of 2017, correct?
Yes, ma'am.
And in 2017, you never called or contacted Coley Pritchett to speak with the child during 2017, correct?
Christmas?
At all in 2017. You didn't have any phone contact with Coley Pritchett to say, hey, can I talk to my daughter? Will you FaceTime with me? Anything like that?
Yes, ma'am.
That's correct?
Yes, ma'am.
You did not?
Yes, ma'am.
Okay. Now, in specifically from December of 2017, when you were in for Christmas and didn't see the child until April 23rd of 2018, when this petition was filed, you had no contact with Kinsley, your child, correct?
Yes, ma'am.
That's correct? Okay. Now, Your Honor, we would ask that the parenting plan be made the first numbered exhibit, and I can.
Mark it as Exhibit 1.
So you would agree with me, Mr. Keel, that you had court-ordered visitation that you didn't exercise, correct?
No, ma'am.
No, ma'am,
I
what?
was never given the opportunity to take Kinsley.
Okay. I sent you some discovery where I asked that you provide to me proof of any efforts that you made to see the child. May I pass this to the witness, Judge? That Miss Coley Pritchett blocked. Do you remember me asking you that?
I'm sorry, what was the question again, ma'am?
Specifically, question number 12. If you'll turn to page 6, question number 12. Do you recognize that as the questions that were given to you to answer under oath, sir?
Yes, ma'am.
And did you answer those questions under oath, sir? In fact, you signed those in front of a notary that I have here in my hand. That is your signature on the last page. Is that correct, sir?
Yes, ma'am.
All right. Now, under question number 12, it asks, explain all actions or inactions that you claim Mr. or Miss Pritchett have done in an effort to hinder your efforts to visit the minor child, Kinsley Brooke Keel. Do you see that question?
Yes, ma'am.
Okay. And your answer was, every time I get to see my daughter, it's only short 30-minute or less visits because they always have somewhere to be. I'm never allowed to take her. Coley always has to be there. Visits are usually somewhere odd or uncomfortable. She makes our daughter seeing me like punishment. Coley takes hours or days or sometimes never replies to text messages and won't answer calls. She blatantly told my mother if she didn't let me talk to my daughter or show pictures of me, my mother could not see Kinsley. That was your answer, correct?
Yes, ma'am.
And I asked you to produce your phone records and text messages that would support any of these efforts that you say Ms. Pritchett made to hinder your visitation. Do you remember me asking you to produce those?
Yes, ma'am.
And you didn't produce any text messages or any phone records to support your allegations of what you're saying, correct?
Yes, ma'am.
Okay. Have you seen the exhibits that I have presented to your attorney of Ms. Coley Pritchett's phone records?
No, ma'am.
Okay. Would you be surprised if they do not exhibit any phone calls from you during the relevant periods that you're talking about?
I don't know if that was when she changed her phone number, if that was her new phone number or old.
Okay. Well, what phone number did she have at the time of the divorce?
Honestly, could not remember, ma'am.
Did you have it in your phone?
I did at the time, yes, ma'am.
Okay. What was your phone number at the time of the divorce?
It's the same, 2466.
I'm sorry?
It's the same phone number.
What is that phone number?
931
Mm-hmm.
627 2466.
Okay. And you mentioned you didn't know if it was before or after she changed her phone number. If you don't know her phone number, how do you know she changed her phone number?
I know her new phone number. I don't know if the calls and texts I used to give her were from her old number or her new number.
Okay, so you do know her new phone number.
Yes, ma'am.
And what is that number?
I would have to look at my phone and tell you.
Okay, so you have that in your phone, and how long have you had that new phone number, sir?
Whenever she changed it, ma'am.
Okay. Okay, number 16 of those questions on page number 8. I ask you to describe any efforts you've made to secure visitation, telephone contact, or any other contact with the minor child, Kinsley Brooke Keel. This would include any filing of any court, phone calls, attempts to visit. If you have phone records or photographs, text messages evidencing your attempts, please attach these to the request for production. Your answer was, I text Coley every time I'm home to see Kinsley since the divorce, except one Christmas because I was sick, and I'm assuming that's Christmas of 2017.
Yes, ma'am.
Every time I see my mother, we talk and send pictures. So we went over just a moment ago the times you were home, and you said birthdays one time a year up into 2019, and Christmas of 2016, Christmas of 2017 when you didn't see her, and we're going to talk about Christmas of 2018 here in just a minute. But those are the only times you've been home, correct?
Yes, ma'am.
Okay, so that's when you're talking about attempting to see Kinsley when you're home.
Yes, ma'am.
Other than that, you're not attempting to call her phone to have a FaceTime visit, to have a talk visit on her phone at all during those periods of time, correct?
Yes, ma'am.
And specifically for the 4 months prior to the filing of this petition, which was filed on April 23rd of 2018, from December of 2017, 23rd to April 23rd, you had no contact with this child, correct?
No, ma'am.
Okay. And you didn't file any court filings since January 28th of 2016 to try to enforce any sort of visitation with this child, have you?
No, ma'am.
Pass it, Judge. Oh, I'm sorry, Judge, I needed to introduce his interrogatories and requests for production.
Mathis?
Mr. Keel, at the time of your divorce in January of 2016, what was your employment?
I was in the Marine Corps, sir.
Where did you reside?
Virginia,
Or whereabouts in Virginia?
Hampton, Virginia.
Okay. And where did your now ex-wife and daughter reside primarily at that time?
Dover, Tennessee.
Okay. Now, the parenting plan that was admitted as an exhibit that you all negotiated as a part of your divorce talks about you having visitation once you are out of the military. Was that your understanding of your agreement with your now ex-wife, that your visitation wouldn't begin until you were out of service?
Yes, sir.
Okay. And why was that what you all agreed to?
At the time, I didn't have a lot of money. I was sending it almost all to her. So I was living in a really crappy apartment that I didn't want my daughter at. And I was trying to plan on moving back to Tennessee.
Okay. And when did you get out of the Marines?
2016,
At what point in 2016?
May, sir.
Okay. So beginning in May of 2016, that's your understanding of when your visitation under this parenting plan would begin. Is that right?
Yes, sir.
Now, what it says is basically under most of these sections, y'all are going to agree, but there are some specific dates that Ms. Turner mentioned. And it also notes under the day-to-day that you can have visitation during the week. But you didn't live here, did you?
No, sir.
How would you have exercised that type of parenting time living in Virginia?
Not that, sir.
Okay. How frequently did you come home to Tennessee?
It was usually just for Christmas and Kinsley's birthday.
Okay. And had you and your ex-wife discussed that those would be the times that you would primarily return to Tennessee and ask to see the child?
No, sir.
When you did return to Tennessee, did you ask to see your daughter?
Yes, sir.
You mentioned that you saw her for her birthday in August of 2016 and then again on Christmas of 2016.
Yes, sir.
Did you make any other trips to Tennessee in 2016 and fail to see your child?
No, sir.
Okay. And then in 2017, did you continue to reside in Virginia?
Yes, sir.
And did you come home on her birthday?
Yes, sir.
Did you see her on her birthday?
Yes, sir.
Now, you mentioned seeing her at the party. Did you ask to see her more than that?
No, sir.
At any point during your time in Tennessee for her birthday, did you request additional time with her beyond simply attending the party?
I would ask to take her, but I was never allowed to do that.
Okay.
The only option was for Coley to bring her or me come to her.
Okay, so you requested of the petitioner that you be allowed to take the child with you while you were here, and she denied that request.
Yes, sir.
And that was for the child's birthday in 2017.
I don't know that it was for the birthday. I'm sorry.
Okay. Well, how many such requests did you make to take this child with you while you were in town?
It was usually on Christmas so that she could spend time with the family.
Now, you said that your ex-wife would tell you you couldn't do that, but you understand you had a court order that said you could. Why didn't you just try to enforce it?
We thought about getting cops involved. But I mean, it's Christmas. That's a messy thing to do on Christmas to a small child.
Well, did she make any threats or other statements about your ability to enforce the court's order?
No, sir. Wouldn't let me have her.
Okay. Now, you said you didn't have visitation for the Christmas of 2017. Explain to the court why that is.
I had the flu. I guess got sick on the airplane, and I was bedridden pretty much the entire time I was home until I left.
So you were physically unable to visit with the child during that time. Is that right?
Yes, sir.
After the Christmas of 2017, did you see her again?
Yes, sir.
Okay. When did you see her next? Her being your daughter, I apologize.
It would have been either a birthday or Christmas.
Okay. Have you seen this child since the filing of this petition?
Yes, sir.
Okay. So you have had some visitation with her since this has been filed. Is that right?
Yes, sir.
Okay. Specifically for the court, when have you seen her since the petition was filed?
Christmas of 2018 and 2019.
Now, you said that there were no phone calls to the mother during 2017. Why is that?
I only talked to Kinsley through my mom.
Okay. And your mother lives here locally, is that right?
Yes, sir.
Okay. She had a good relationship with your now ex-wife and the child, correct? All right. And so during the times that we're discussing and you were living in Virginia, she was here. Was she seeing your daughter regularly?
Yes, sir.
Okay. To the best of your knowledge, how frequently was she seeing the child?
Say once every week or two.
Okay. And when she would see the child, is that when you would talk to your daughter?
Yes, sir.
Okay. And what type of contact did you have with her? Was it via phone? Was it FaceTime? How were you interacting?
It was usually just phone. We were working on FaceTime now.
Okay. Did your mom take pictures and send those to you?
Yes, sir.
Did you send pictures back to her?
Yes, sir.
Okay. So you were talking to your daughter on the phone and she was seeing pictures of you and you were seeing pictures of her whenever your mother would interact with her.
Yes, sir.
And you think that was occurring on approximately a weekly basis?
Yes, sir.
Did you consider that to be substantive visitation with the child, getting to see her and speak to her regularly,
Yes, sir.
given the geography and the fact that you lived in Virginia?
Yes, sir.
When did that stop?
It stopped I want to say somewhere between October and December of 2017.
Did you speak to your ex-wife about why it stopped?
I did not.
Well, did you get a text message from her in January of 2018? That you recall? I'm going to hand you
And
to refresh your recollection.
I have not received this text. This is the first time I've.
It was produced into Miss Massey's. It was produced as a response to Miss Massey's original discovery requests. We got two separate sets of discovery requests in this action. One from Miss Massey when she was counsel, and then a second set from Miss Turner when she took over representation.
I never produced discovery. It was Sharon Massey's discovery. Her name is actually on it. And you gave
we have
me
two separate ones,
answers back in November of last year, but no production of documents. And I got a sworn copy last month with no production of documents. This is the first time I'm seeing this, and it's not in Miss Massey's file.
Well, if the court doesn't want us to admit it as an exhibit, I think I can still let the witness review it for purposes of.
Turner, review it first and find out whether she has an objection to it.
I don't have an objection to it, Judge.
Can you not? All right, then you may proceed.
If you would take a moment to review that for me, Mr. Keel. And let me know if you recognize that correspondence.
Yes, sir.
Okay, tell the court what that message is.
It was a message requesting that I sign over my rights for Kinsley.
Actually, you just read the message rather than characterizing the message, just.
Rather than interpret it, let's let him read the message.
Go ahead and read it, sir. Hmm?
Hey, so I'm about to renew the kids' insurance for the year. Kinsley's starting sports in school this year. She completely thinks she has a normal life, and I'm beyond grateful every day for that. I seriously thank God every day that she doesn't have to have a split family, but she will find out she has a different last name than the rest of her family. When all this occurs, I want to protect her as much as possible from the brokenness. I told your mom I would even allow her to come over and do all that normal stuff if she would stop spending their bonding time trying to cram her head with you. It is confusing Kinsley so bad and completely not good for her. And your mom agreed and said she wouldn't do that anymore. I am asking for the bottom of my heart, if I send you papers to sign your rights over, we can do this civilly. She can still have her Nana and Pop, that is fine, but she can finally have the normal, perfect life she deserves. I'll pay for everything and you won't have to pay child support.
Okay. Is that a text message that you received from your daughter's mother on what looks to be January 30th of 2018?
Yes, sir.
Okay. And she acknowledges in that message that she doesn't want your mother involving you in the communications with the child anymore.
Yes, sir.
I'll get that as the next exhibit, please, Your Honor.
Mark as Exhibit 3.
And again, you were interacting with the child through your mother on a weekly basis.
Yes, sir.
And do you think the mother's desire to stop that is part of the reason the child was no longer allowed to see your mother?
Yes, sir.
Now, you're court ordered to pay child support under the terms of your divorce, are you not?
Yes, sir.
And are you current on that payment?
Yes, sir.
Mr. Keel, are you asking the court to deny this petition so that you can try to enforce the parenting plan that was originally agreed upon and develop a more meaningful relationship with your daughter?
Yes, sir.
When you were being allowed to see her through your mother, do you think you had a meaningful relationship with her?
Yes, sir.
When she would see you, did she know who you were?
Yes, sir.
When you talked to her on the phone, did she acknowledge you as being her dad?
Yes, sir.
Those are all my questions, Your Honor.
Redirect.
Yes.
Mr. Keel, you said that you couldn't come down anytime. Well, first of all, where were you stationed?
Yeah. Norfolk, Virginia.
Norfolk, Virginia. How far of a drive is that, sir?
12 hours.
Okay. And military people have what they call Donza days. Yes, sir?
I'm not sure what that is.
You're not sure what a Donza day is? Days off for like holidays, such as you get some days for Thanksgiving around the actual holidays that you're not actually going in and working.
Yes, ma'am.
You have Donza days around Martin Luther King Day, President's Days, and other days during the year that they actually give you holidays from work in the military service, correct?
Yes, ma'am.
And you, even though you had Thanksgiving every other year, pursuant to the court order, you never took the time to come down and see your child during that time, correct?
Yes, ma'am.
And during the year when you would have Donza days, you wouldn't take the time to drive down and see your child, even though the court order gave you the opportunity to do that, correct?
Yes, ma'am.
All right. And during the summer, around 4th of July, another time you could come down and spend a little time with your daughter that you chose not to do, correct?
Chose not to? No, ma'am.
Well, sir, if you had the days off and you could come down pursuant to the court order and you didn't, how else would you characterize that, sir?
I didn't have the money.
Okay. Well, and you never contacted Miss Pritchett, like you said before, on the phone to try to either FaceTime or talk on the phone with your daughter during this period of time, correct?
Through her? No.
All right. Now, let's talk about that Christmas 2018 visit. Yeah, there was actually court in December of 2018, and that's why you were down here in town, correct?
Yes, ma'am.
And you asked to come over to Coley's house, Miss Pritchett's house, to see your daughter, and it was supposed to be you coming over to see the child, correct?
Yes.
You showed up, and it was you and your mother and the grandfather, your brother, and a niece. Is that right?
Mother, father, brother,
Mm-hmm.
niece, and nephew.
Okay. And you didn't say 10 words during that entire 30-minute visit to the child, did you?
That is not true.
Okay. Your mother was cornering the child and showing her pictures of when she was a baby, saying, "This is your daddy, sit by your daddy. I want to take pictures of your daddy," forcing that on the child, correct?
Also not true.
Okay. And the visits that your mother had with the child during 16 and 17 before they were ended in January of 18 were only once every couple of months. It wasn't once a week, was it?
No, ma'am, that's not true.
Okay. So if Miss Pritchett testifies it was only once every couple of months, is she lying?
Yes, ma'am.
Okay. And during those visits, they would be like outside at a park, out at the playground.
Yes, ma'am.
And your mother would be following the child around with the phone trying to say, "Talk to your daddy, talk to your daddy, talk to your daddy." Correct?
No, ma'am.
Okay. The visit that ended your mother's visiting with the child was in January of 2018 when she saw the child at a dance studio. Do you remember that? She took the child into a room, shut the door, closed all the blinds, and wouldn't let Miss Pritchett in when she was in there with her child, with your child. Do you know about that?
No, ma'am.
Okay. Would that be concerning to you if your mother did that with Coley Pritchett present? And so as you sit here today, is it your testimony that you believe Coley, the child, Kinsley, knows you as her father?
Current
Yes.
today? No, ma'am.
Now, you said you saw this child in Christmas of 2019, and my client says you did not. Are you certain you saw this child in Christmas of 2019? Or was the Christmas of 2018 visit at her house the last time you saw this child?
That might have been the last time, ma'am.
Mathis,
Nothing.
I have a question for you. The answer to the petition for adoption and termination of parental rights that was filed on your behalf was styled the following: an answer to petition for adoption and termination of parental rights and motion for DNA testing. And then the last paragraph, on paragraph 30 of that answer, respondent, which is identifying you, respondent would request that the parties be ordered to submit to DNA testing. Goes on to say, wherefore respondent prays, one, that the petitioner's petition be dismissed with cost tax to the petitioner. Two, that this honorable court order that the parties submit to DNA testing. And third, that the respondent be granted all such further relief. Did you request DNA testing to establish whether you were the father of this child?
Yes, Your Honor.
All right. Was that ever done?
Yes, Your Honor.
But you at some point did not believe you were the father of this child or had a question about it. Is that correct?
Yes, Your Honor.
All right. Anything further?
No, just.
Mr. Math?
And just to clarify where that, I've got a couple of questions about
That's
that.
fine.
This is, I think, alluded to in the original petition. Mr. Keel, what is your understanding of the relationship between the petitioner, or I should say the history of the relationship between the petitioners?
I'm not sure of the question, sir.
Okay, well, your ex-wife has a child from a previous relationship prior to your marriage to her. Is that correct?
Yes, sir.
And is the current petitioner the father of that older child?
Yes, sir.
Okay, so were you with her while they were going through their separation?
Yes, sir.
So at some point, did you actually facilitate the visits between the petitioners as it relates to their other child? Did you transport your wife's older child to visit with her now husband?
I went with him a few times, but I wasn't driving.
Okay. So at some point, did you develop concern when their relationship rekindled that potentially your daughter was in fact his daughter and not your own?
No, sir.
Then why did you ask for the DNA test?
We got divorced under the grounds of an affair.
Between your wife and the petitioner who is now the co-petitioner who is now her husband, correct?
No, sir. Another man.
Okay. So you were concerned it was a third party's child.
Yes, sir.
That's all right.
Mr. Keel, if you were concerned that this child was not your child when you divorced Miss Pritchett, why did you not ask the divorce court for a DNA test?
We didn't go to court for it. I kind of folded on the divorce.
Did you have an attorney?
Yes, ma'am.
That's all I have, Judge.
Thank you, sir. You may step down and have a seat by your lawyer. Ms. Turner, you may call your next witness.
I would call Holy Pritchett.
State your name for the court, please, ma'am.
Holy Pritchett.
And you've got a soft voice, Chloe, if you'll speak up just a little bit. You are the mother of Kinsley, is that correct?
Yes, ma'am.
And you are married to Mr. Pritchett seated here at council table, the co-petitioner, is that right?
Yes.
When did you and Mr. Pritchett marry?
You scoot up just a little bit towards that microphone and make sure we can hear it, okay?
January of when? What year did you marry Mr. Pritchett?
2017.
Okay. And have you and he lived together continuously since that time?
Yes.
Has he had physical custody of Kinsley since that time?
Yes.
And when the divorce went down in January of 2016 and we've introduced the parenting plan, did Mr. Keel request to visit with Kinsley at all other than her birthday or Christmas in 2017? Did he call you and ask to talk to her on the phone in 2017?
He didn't see her at all 2017.
Okay. My question is did he have your phone number?
Yes.
Okay, and I have some phone records and I'm gonna pass these forward to you. Did you please?
These are my phone records from 2017.
Forward for 2017? And in 2017, I think they go on to actually through 2018. Do they reference whether Mr. Keel has attempted to call your phone during those time periods?
Yes, ma'am, there's none in there.
Okay, and do they go through November 23rd of 2018?
Yes, ma'am.
Specifically, this petition was filed on April 23rd of 2018. Do these phone records from July 25th of 2017 through November 23rd of 2018, do they reflect any phone calls from Mr. Keel?
No, ma'am.
Then we'd ask that be made the next numbered exhibit. So aside, Ms. Pritchett, from the times that Mr. Keel's mother saw the child, did he have any phone contact with the child after the divorce? Through your phone?
No.
Or through anybody else's phone other than his mother's phone? Okay. How often would his mother visit with Kinsley?
Ever more than once a month.
Okay. When you heard Mr. Keel say that she was visiting with the child weekly, is that true or untrue?
Untrue.
And would she be seeing the child, you said never more than once a month, would she be seeing the child every month? And so it was once a month or once every other month? Would that be a fair characterization? Where would she visit with the child, and would that be in your presence?
Sometimes it was at my house, at the park, or her dance studio, and I was always there.
Okay, and whose dance studio?
Hers.
Does she teach dance, or does she have somebody teach? Okay. And when Kinsley would visit with Mr. Keel's mom, what would occur during those visitations?
Sometimes she would have her phone, well, she was always on her phone, but sometimes I would see her trying to give Kinsley the phone. And Kinsley would always try to be running away from the phone. And I would ask her in the car, like, who are you talking to? And one time she said, I think it was her dad. She had no clue who she was trying to get her to talk to, but she never once was physically talking on the phone.
Okay. And how long would those visits be with Mr. Keel's mother?
30 minutes.
Did you raise the issue with Mr. Keel's mother about this pushing the phone on Kinsley during her visits?
Yes.
And what did you tell Mr. Keel's mother about that?
That I would prefer her to spend her time just having a relationship with her. I said she thinks she has a mom and a dad at home, and then she comes here and you're showing her a picture of a man saying, this is your dad, this is your dad. And that's confusing her. And I don't mind at all you being her grandma, her nana. I said, but, please stop spending your time doing this to her. Just have a relationship with her.
When she was doing that during the visits, how was Kinsley reacting to that?
Scared. I mean, she was running away. She did not want to.
During the last visit with Mr. Keel's mother in January of 2018, 4 months before you filed this petition, what happened on that visit?
Okay, I was sitting out in like the waiting room of her dance studio, and there's like blinds, and she took her in the gym part, and then she shut the blinds and she shut the door, and I sat there and then I thought, okay, I really don't have to sit here.
Was that
I'm going
concerning
in
to
there.
you?
Yes. So I went in there and just kind of sat down.
And what was she doing?
And she just told me, would you get out? And I was like, I'm not hurting anything. I mean, I'm just sitting here. And she said, no, you need to get out. And I said, I'm not going to get out. So you can just put her on the phone with Ben or something. And she said, no service in here. So I said, I'm sitting here, you can play with her. And then that's whenever I told her that I was going to text Ben and ask. I said, I'll do the one to see if Ben wants to be in her life. And that's when I sent Ben that message.
This message that was just introduced into evidence?
And he never even wrote me back after that.
Did he ever respond to this text?
No.
Okay. Did he ever say, no, I don't want to terminate my rights. I want you to give me visitation as court ordered?
No.
Nothing along that. And this was January 30th of 2018 that you wrote it. Correct?
That was right after our visit.
And we heard from Mr. Keel that he had not visited that Christmas before in 2017 because he said he was sick. Did anybody call you and tell him he was in town and he was sick?
Yes, he was hanging out with friends.
Did he call you?
All right,
Oh,
there's an objection on the floor, and it's objection to foundation for knowledge. Sustained as until you lay a foundation.
Did Mr. Keel call you and tell you he was in town for Christmas?
no.
Did his mother call you and tell you he was in town?
2017,
No.
just so I'm clear.
December of 2017. When he didn't visit and he says he was sick with the flu, did he or anybody from his household, his mother, call and say, oh, we're here, we can't visit because he's got the flu? No? Okay. Did you hear anything between December 23rd and April 23rd from Mr. Keel about visiting, calling, talking to the child, anything like that?
No.
And the last visit you had with Mr. Keel's mother was before this text of January 30th of 2018? Okay. And as far as you know, from what she told you, she didn't even have phone contact with Ben that day with the child, correct?
Yes.
Now, what kind of relationship does Kinley have with your husband, Eric Todd Pritchett?
That's her father. That's all she knows is her dad.
What does she call him?
Dad.
Do you have siblings in your home? And how many children do you have total, Miss Pritchett?
One, and then Eric has a son. We have a stepson, and then we have a daughter together.
Okay, so there's 3 children total in your household? And one is Mr. Pritchett's, that your stepmom? One is your daughter that you have together with Mr. Pritchett? And there's Kinsley. What are their ages, please?
8, and then 11.
Who's 8?
Both of them, the Kinsley, Jackson, and then Callie's 12.
And then you have a baby? I'm confused.
Boy and a girl, both 8,
Okay,
and then our oldest is 12.
okay. The oldest child is with the one that you have with Mr.
Yes.
Pritchett, is that right? Okay, I'm gonna pass forward some photographs to you, Ms. Pritchett, and see if you can identify those. Are those photographs that you have provided to me? And would you please explain to the court what's referenced or what's exhibited in these photographs?
Yes, that shows how little they were when she first came, or he first came in our lives, that she's known him as dad.
So, Your Honor, may I just go ahead and pass these forward to the court so we can go through those together?
Go ahead and be one of those. I think these are all the same. correct?
They are the same, Judge, and all in, should be all in the same order. On page 1 there, what have we got?
That is Kinsley and Jackson.
How old are they there?
Oh, tiny, still passies, and
Is that when you were married to Mr. Pritchett?
yes. And here, the second one is,
That Mr. Pritchett in the background on the dock there?
yes,
Y'all fishing?
yes.
Okay, what's exhibited on the next page?
That's Kinsley Jackson, then Callie Kinsley Jackson.
Okay, and the next page of pictures?
That's all of us, and then the bottom one is us and one of our nieces.
Okay, what's on the next page?
All of us, and then them fishing again.
Okay, and the next page?
fishing.
Y'all do a lot of fishing.
Yeah.
And the next page?
That's their great grandma, which is Eric's grandma. And then my dad and Kinsley.
Okay, next page?
Kinsley is my brother.
Hmm, okay,
That's us, and then Kinsley and Callie at Christmas.
okay,
And that's us on Christmas.
all right, next page?
Kinsley and Callie.
Okay, next page?
It's probably a birthday party.
Do you know which birthday that is?
5. She's hold number 5.
Okay, was Mr. Keel present for that birthday party?
No.
Okay, so when he testified, he was at every birthday up until 2019, is that true?
No.
Okay, what's on the next page?
Trick or treating.
Mm-hmm. What's on the next page?
Camping at Piney.
Okay, what's on the next page?
Holiday World.
Okay, and the next page? Okay. Y'all very involved in church? Okay, what's the next page?
Creek, and then it's Bible school underneath that.
Okay, is that Jackson and Kinley underneath that?
Yes.
Okay, what's on the next page?
Church, and then on the boat.
All right, and the last page?
And that is Piney again.
Okay, is Kinsley, you know, we'd ask those pictures to be maybe the next numbered exhibit. Is Kinsley a happy child?
Yes, she's a well child. She's very happy though.
Does she know Mr. Keel as her father?
No.
Okay. Now, you heard Mr. Keel talk about Christmas of 2018. Did you allow him to come to your house in Christmas of 2018? And what happened on that occasion?
Like you said, they all came in, and she hadn't seen him since 2016, I believe.
How did Kinsley react to that?
So, of course, she didn't know who any of them were. And they say I make it like a punishment, but that's not true. She doesn't know who they are, so she is scared. And that's not my fault. She grabs onto me, and I'm like, go see him.
And then what happened?
And Liz is like, go see
Who's
him.
Liz? Who's Liz?
Ben's mom.
Okay, and she told her to go see her dad?
Go see with your dad. And she'll say, Daddy, grab her. Here, let's take a picture with Daddy. And she does all the talking, and
Liz does all the talking?
yes, ma'am. And
Did Mr. Keel speak to Kinley?
Kinsley.
Kinsley, I'm sorry.
I sat in the other living room, which isn't probably 10 feet away, and did not hear him say more than 2 sentences.
How did Kinsley react to that visit?
After they left, I asked her, who was that?
Checked whatever the child said. Sounds like.
State of mind, Judge. I mean,
Overruled.
Just so you know.
yes.
And I took a video of it and can't find the video whenever I was asking who it was. And she said, I don't know. And I was like, no, who was in there? And she said, she don't know. And I said, well, who did Liz say it was? And I knew who she was telling her it was. And she said, Eric. And she only said Eric because that's who she associates Dad with. And I'm sure she didn't want to say Dad, but was guessing the name. But that's who
She was associating Dad with Eric.
Yes, and she said Eric. But I mean, other people witnessed her say that too. My other family was in there.
Now, initially, you heard Mr. Keel say that he visited with Kinsley in Christmas of 2019, and then he said maybe that's not true. Did he visit with Kinsley in 2019? Okay. And again, has he, even since his petition's been filed, has he contacted your phone, tried to talk with Kinsley at all?
No, ma'am.
And after you cut off visitation with his mother after the January incident, has she seen the child since that time?
No, ma'am.
With regard to Kinsley going forward, you're asking the court to terminate Mr. Keel's rights and ask that Eric be able to adopt Kinsley. Why are you asking the court to do that?
Just to make legal what's already our life. I mean, that's all she knows.
Do you think that's in her best interest?
Absolutely.
If she were forced at this point in time to go visit with Mr. Keel, based upon what you've seen, how would she react?
It would honestly be terrible, especially with her personality.
Does she know that her last name is different from her siblings?
No.
Okay. Does she think she is Pritchett?
Yes.
Are you asking the court to change her name, allow the adoption, and change the name? And do you think that's in Kinsley's best interest?
Yes.
Pass the witness, Judge.
Mathis?
Miss Elizabeth Keel did have a visit with the child in January of 2018. Is that right? Had it been her pattern during these visits to involve Mr. Keel remotely via phone?
I'm not sure.
Well, you said you were there for every visit. Wasn't she calling Mr. Keel on the phone to talk to the child during the time that she spent with the child?
She had her phone. I don't know what she was doing on it.
Didn't you terminate her contact with the child because she was allowing interaction with Mr. Keel?
No.
Well, didn't you send a message in January of 2018 that alluded to the fact that his mother was continually filling the child's head with ideas of him and that you didn't want that to keep happening or she wasn't going to get to see the child?
To who?
To Miss Keel.
I can't recall.
Okay. Was January of 2018 the last time you allowed this child to interact with Miss Keel prior to the Christmas visit?
Yes.
And during that visit, was she attempting to contact Mr. Keel? Is that the reason you terminated the visit? You said she went in a different room and you were worried she was going to call Mr. Keel. Is that right?
Yes.
Okay. And you did not want that to happen, did you?
No.
You did not want your daughter to have communication with this man, correct?
If he wants to communicate, it could go through me. I wanted her to be a grandma.
But you did not want her to allow communication between this child and this gentleman. Is that right?
Repeat the question.
In January of 2018, Elizabeth Keel, the paternal grandmother of your daughter, had a visit with the child. You were present for that visit, correct?
Yes.
And during that visit, she was going to allow the child to speak with Mr. Keel, correct?
No. I mean, she said there was no service. She wasn't.
Were you worried that's what she was going to do?
I don't know what she was going to do.
But you testified under direct examination that that's what you were worried she was going to do.
She done a lot of stuff like that.
Okay. And is her allowing that contact with Mr. Keel the reason you stopped allowing her to see the child?
Some of it.
Okay. So you admit he was having contact with the child through his mother when she would see her?
Possibly.
Okay. Now, if he had been well Christmas of 2017 and asked to see the child, would you have allowed that?
Yes.
Okay. Why didn't you let him take the child whenever he would visit with her?
She didn't know him.
But you admit you wouldn't let him take her out of your presence, correct?
Correct.
Those are all my questions for her, Your Honor.
Mr. Turner?
The incident in January of 2018 with Liz, did it concern you that she took the child in the other room, shut the door, drew the blinds, and would not allow you in?
Yes.
Is that what concerns you?
Yes.
In the prior visits, when she was trying to call and put Mr. Keel on the phone, you talked about a moment ago in direct how that affected Kinsley.
Yes.
Did it affect her negatively?
Yes.
And were you asking Ms. Keel not to do that because it was affecting your child negatively?
Yes.
That's all I have, Judge.
Mathis?
Nothing further, Your Honor.
Thank you, ma'am. You may sit down. Mr. Turner, you may call your next witness.
Eric Todd Pritchett.
Pritchett, if you'll come around, please. Raise your right hand and face our clerk.
You solemnly swear or affirm that the testimony you're about to give is the truth, whole truth, nothing but the truth, so help you God.
Todd Pritchett,
And Mr. Pritchett, how long have you and Miss Pritchett been married?
since 2017, January.
A year after the divorce?
Yes, ma'am.
And prior to the marriage, did you all live together at all, or did you just move in after the marriage?
We were together before a little bit.
So how long have you had physical custody of Kinsley?
I'd say fall of 2016, at least.
Okay, so several months after the divorce.
Yes, ma'am.
And how old was Kinsley then?
Oh, goodness. Year and a half, 2 years old.
Okay, so now that I got straight, you and Miss Pritchett have an older child, correct,
Correct.
together?
Yes, ma'am.
And then you have another child that's Kinsley's age?
Yes, ma'am.
And that child's name's Jackson?
Yes, ma'am.
Now, what is Kinsley's relationships with her siblings like?
A normal child, just brothers and sisters.
Are they close?
Yes, ma'am.
Okay. You were around in 2016. You heard Mr. Keel testify that he only had visitation on birthdays and Christmases. Is that what you remember?
Yes, ma'am.
Did he ever call and speak with Kinsley on the phone?
Not that I'm aware of.
And during that time when you began living with Kinsley, did you start developing a relationship with her, a father and daughter?
Yes, ma'am.
And tell the court a little bit how that progressed.
I mean, it was when you're around her 7 days a week, it just became normal. I mean,
Has she bonded with you?
yes, ma'am.
Does she call you daddy?
Yes, ma'am.
Okay. During the time that she has been around Mr. Keel, have you been present for any of those occasions?
No, ma'am, I wouldn't say present. The 2018 visit, I was at the house, but I wasn't in the room or anywhere to say of.
Was that intentional? You just kind of wanted to get out of the way? And I think I may have asked you this and I asked her, she calls you daddy.
Yes, ma'am.
Does she know you as her father?
Yes, ma'am.
Does she know Mr. Keel at all as her father?
No, ma'am.
Are you asking the court to terminate Mr. Keel's rights and allow you to adopt Kinsley?
Yes, please.
You understand that if the court does that, it will be as if Kinsley were born to you.
Correct.
She can inherit from you and you can inherit from her.
Correct.
You would have obligations, not just the benefits of being a parent, but you're going to have the obligations, and you understand that.
Yes, ma'am.
In fact, have you been doing that since 2016?
Yes.
Are you asking the court just to formalize that?
Yes, ma'am.
And do you think that that's in Kinsley's best interest?
Yes.
Pass witness check.
No questions this week.
Thank you, sir. You may step down.
I may have just a brief moment.
No. Wiggins, I haven't given you an opportunity to ask questions. Did you want to ask questions of any of these witnesses?
Judge, I would interject.
I was going to say, if you do find that you need to ask a question, please stand and
Judge,
tell Bailiff Dale, and he'll zap me or something to let me know.
everybody's been very thorough. There is one thing that Mr. Mathis and I just discussed. This matter's been going on, I think, 3 years, close to it. When we were initially at court, when I spoke to Mr. Mathis, I recommended no visitation. While I also thought this matter could resolve quicker, but of course, COVID and everything else. But I didn't want to disrupt a minor child, confuse her, and recommended no visitation till the matter was resolved.
All right, Ms. Turner, you have another witness?
I do, Your Honor. Gary Dacus.
You are Gary Dacus, is that correct?
Yes, ma'am.
And Mr. Dacus, how are you associated with this family over here?
Married to Miss Coley's sister.
Okay, and her name is Megan?
That's correct.
How long have you and Megan been married?
Since 2008.
Okay. And where do you live in proximity to Miss Coley Pritchett and Mr. Eric Pritchett?
Roughly 150 yards northwest through the woods.
Are y'all neighbors?
Yes, ma'am.
Okay. Do you all have children, you and your wife, Megan?
Yes, ma'am, we do.
And are your children close with the Pritchett children?
Together every day.
And does that include Kinsley? Is your Kinsley close to your children?
Yes, ma'am.
All right. Do Kinsley and her siblings stay overnight at your house?
Yes, ma'am.
Do your kids stay overnight at the Pritchett's house?
Yes, ma'am.
Okay. Tell the court a little bit about Kinsley's relationship with Eric, the petitioner who's asking that he be able to adopt her.
Yes, ma'am. So in my opinion, Kinsley portrays Eric as her father. She calls him dad. She treats Eric like my children treat me. The girl wanting to be with daddy and sit with dad and hold dad's hand and seek dad's advice on certain things and go to dad when she's hurt. It's just similar how I see my children relate to me as I do Kinsley with Eric.
Have you been around as a family member to see Mr. Keel and Mr. Keel's involvement with Kinsley since the divorce in 2016?
Have I seen Mr. Keel and Kinsley's involvement since 2016?
Since the divorce in 2016?
Not that I recall of any, no ma'am.
Okay. And you've been around for birthday parties, Christmases, holidays,
Yes.
and the like?
Yes, ma'am.
Has Mr. Keel been present in any consistent fashion in Kinsley's life at those events?
Since the divorce?
Yes, sir.
Not that I can recall.
When Kinsley stays at your house, is she homesick to go home?
Sometimes at bedtime when it's like, hey, time for y'all to quiet down, maybe, but she stays the night.
And what sort of things have you seen Eric do with Kinsley that would denote that he's a good father figure to her?
Just spending time with, playing with, buying things for, and just
I've seen a lot of pictures. Apparently they fish a lot. Do they fish?
Eric fishes all the time, so I don't know who he's got with him half the time, but yes, that does surprise me.
Okay. Do you see any reason that it wouldn't be in Kinsley's best interest for Eric to be legally her father?
No, ma'am, I do not.
Questions this way.
Thank you, sir. You may step down.
Thank you.
You can have a seat in the courtroom, Mr. Jacob, if you like.
Approved, Judge.
Fine. Petitioners have rested, so let's go ahead and take our morning recess, and then we'll start with the defendant's proof if you wish to offer. Stand in recess for 15 minutes.
All rise.
Petitioner has rested, so Mr. Mathis, you wish to offer any proof?
Oh, Elizabeth Keel, Your Honor.
Elizabeth Keel.
If you would please state your full name for the court, ma'am.
Elizabeth Sophie Keel.
Ms. Keel, you are Mr. Benjamin Keel's mother, is that correct? And Kinsley Keel's paternal grandmother, is that right? Okay. Now, your son and your granddaughter's mother divorced back in January of 2016, is that right?
Yes.
Okay, I want to focus on your relationship with your granddaughter from when they got divorced up until this petition to terminate his rights was filed, okay? So after they divorced, what type of interaction did you have with your granddaughter?
As much as I could go.
Okay, and if you would be specific for the court in describing how often you got to see her.
I got to see her sometimes every week, sometimes every couple of weeks. And then there were periods of time where I wouldn't get to see her because Kinsley was supposedly sick or they had other plans or whatever.
And if you would spell out for the court, how were these visits occurring? You would text the mother and meet up, or she would call you?
I would text her, and sometimes it would take several times for me to get an answer. And I would beg her to let me see Kinsley. And then when she was little, she was, walking, and I would go to the house and we would go outdoors for an hour and a half and play and hang out. Sometimes we hung out in her bedroom a little bit. And then, of course, the visit's over. But she was little then. And when she was older, we would meet at the playground, or if we had to, at McDonald's or wherever, but just as many places, occasionally at the studio, at my business. But just as many places we could. But around the time that Kinsley started talking, then I was no longer allowed to be alone with her.
And whenabouts was that? Because every child starts talking differently.
She was getting close to 2.
Okay, well, remember, I'm asking you to focus on the time from when these parties divorced in January of 2016 through the filing of this petition in April of 2018, okay?
Right, right. So at that point, we were at the point where Kinsley was talking and she was no longer allowed to be alone with me. Mom was with her at every visit. And a lot of times, you know, up close and personal, we couldn't have a word to ourselves.
And were those visits still occurring at places like the park, McDonald's, or your dance studio?
Mhm.
Okay, and how frequently were those visits occurring in 2016 and 2017?
Every couple weeks to few weeks, depending on Kinsley's health.
Okay, and when you were able to visit with Kinsley, did you arrange for her to interact with her father, Benjamin Keel?
Always.
Right, and
I would.
how did you facilitate that?
Well, first I would always show her pictures of her daddy and talk to her about him and tell her, of course, how much he loves her and misses her. And then I would talk to Ben previously and tell him that I was going to have a visit with Kinsley. And so we would do a phone call so he could talk with her. And that worked out until we were at the park one day, the last time that we got.
Well, let's slow down.
Okay.
And you're saying that was happening during every one of these visits that were occurring, I think you said at least every couple of weeks.
Yes,
He
and
was talking to her on the phone and she was being shown pictures of him
yes.
every couple of weeks, every time you saw her throughout 2016 and 2017.
Yes. And
Okay.
if the only time he wouldn't get to talk to her was if, you know, he was in the Marine Corps. So if he was doing something and he was not able to come to the phone, but that was fairly rare. We did pretty good getting some conversations.
And is the reason that that's how he was interacting with her because he lives out of state?
Part of it.
Now, did Miss Pritchett approve of you allowing the child to talk to Mr. Keel?
No.
Did she voice concerns about that to you pretty regularly?
Yeah, well, there was a lot of dirty looks. And, you know, she did not want me talking about Ben or bringing him up or showing Kinsley pictures or anything of the sort.
Now, in 2016, do you know when he came to Tennessee to visit the child?
I believe for her birthday and for Christmas.
Okay. And were you with him during those visits?
I was.
Did you observe him interacting with his daughter?
I did.
Was your observations of their interactions that they were appropriate between a child and their parent?
Absolutely.
Okay. Did he try to take the child with him after the visit?
Well, there wasn't a lot of that because, for instance, at her birthday, we begged and pleaded for details of where is this birthday party going to be. And it was at a place in Clarksville, Kids in Play. And so we all piled in and went up there and spent a couple hours and thought that we were all going to have, you know, birthday cake and presents and hang out and maybe we'd get to take Kinsley. And about maybe an hour in, Cully stood up and said, "We're done, see ya," and packed her up and just left. And
what about Christmas of 2016?
Christmas, we had to beg to see Kinsley, of course. She came to the house.
When you say she came to the house, do you mean that the child's
Cully
mother brought her? Okay.
Mhm. She brought her to the house. She would not leave. I had asked her, can't we just have her by ourselves? Ben asked her, can't we have her by ourselves? No. So she plunked herself down and, you know, we all did. It was a bit uncomfortable, as you can imagine. So we all hung out with Kinsley for as long as we could. And in about 40 minutes, she stood up and said, "Well, we have to go." And they left.
Okay. But the request for the child to get to stay or to be alone with you all were denied
Absolutely.
by the mother?
What?
Let me finish the question before you answer it, okay? The request for the child to stay alone with you all were denied by the mother.
Yes.
Okay. Now, in 2017, are you aware of any visits between Mr. Keel and the child in person?
You know, it's hard to figure out which Christmas it was, but I think it was 2017. Ben came home, his brother and sister-in-law came home, and Ben got the flu and Brittany got the flu and were in bed until the day he left. He basically dragged himself up to get on the plane and go back. So no, he did not get to visit with her. Of course, he was, afraid of giving her the flu. So he did not get to visit with her at all.
But you observed him during the time he was here in Tennessee for the Christmas break of 2017.
Oh, yes.
Was he physically capable of visiting the child during that time?
He was in bed, miserable.
Okay. And throughout 2017, though, did he continue to visit with the child telephonically during your time with the child?
Yes.
Okay. And when did those visits stop?
In 2018, we were at the playground and Ben called, and I called Kinsley over and I said, come talk to Daddy. And she said, no. And she was running around to the playground. So I thought she was being silly. And I said 2 or 3 more times, come and talk to your daddy. And she said, no. And I said, why not? And she said, because Mommy told me not to talk to him anymore.
Okay. Did you have a conversation with the mother about that?
So they got up and left right after that.
Okay. Did you have any conversations with her about that after the fact?
I did.
All right. And what was the substance of that conversation?
She told me at that point that I would not be allowed to see Kinsley any longer as long as I showed pictures of Ben to her, talked to her about her daddy, or had her talk to him on the telephone.
Okay. Did you have one last visit with the child in January of 2018?
I did.
Okay. And did you attempt to facilitate communication between Mr. Keel and the child during that visit?
I did. I asked Coley to leave her alone with me at the studio, and actually Kinsley's older sister Callie was there, and my other grandchildren were there, and she would not leave. So I tried to call Ben because it was a snap visit. I don't think I got a hold of him at that time, and Coley and I kind of had heated words. And then she told me, this is it. You're not going to get to see her any longer as long as you. And so I begged her to please call Ben and work this out. The two of you work this out. She needs both of you work this out. And so
I want to be clear for the court. She told you that if you continued to allow interaction with Mr. Keel, you weren't going to see the child.
correct,
And that was in January of 2018.
correct.
Okay. And but for her stopping that, those telephonic visits would have continued. Would they not?
Absolutely.
Okay.
Yes, sir.
Those are all my questions, Your Honor.
Ms. Turner?
Ms. Keel, are you aware that your son questioned the paternity of Kinsley?
Yes, I am.
Okay, why would he do that?
Well, can I just speak for a minute? When
I asked you a question. Why
I'd
would
be
your
glad to answer it, if I may. When they married, Ben was in the Marine Corps and they moved to Virginia. Coley told me not long after that she wanted to go with Ben to Virginia because her older daughter's biological father was taking her to court for visitation because she wouldn't let him see the daughter. So after the court hearing, he got his visitation with his daughter. And then not long after that, Coley didn't want to live in Virginia anymore. She told Ben it was too scary up there in the big city. So
Are you getting this from what Coley told you when you said Coley told Ben, or is that from something that Ben told you?
which part? I'm sorry.
When you said Coley told Ben she didn't want to live up there anymore.
Well, she also told me she didn't want to live up
Okay.
there anymore. So he agreed to put a double wide on her parents' property and said that after he got out of the Marine Corps, that he would come back and they would build a house together. So it was, I can't remember exactly when it happened, but not long, it was a while after she'd been there. I'm going to say she'd probably been in that house for a year. And someone that I've known for a very long time approached me. I'm answering your question.
Yeah, I asked you, why did your son, you don't have to give me a narrative, just tell
Here's
me,
the answer right
why
here.
did your son, without telling me what someone else told you, why did your son question paternity of this child in April of 2018 when this petition was filed?
Because the marriage broke up because Coley had an affair with a married man.
Okay.
He wanted to establish that the child was his.
Well, why didn't he do that in the divorce?
Because he, I think at the time, was extremely upset. He did marry for life, and he was probably in a little bit of denial about that it could possibly not be his daughter. He wanted Kinsley to be his daughter.
So when the termination petition was filed, asking that his rights be terminated because he hadn't visited with the child, that's when he decides, since he wants Kinsley to be his daughter, that he's going to question the paternity?
I think at that point, it sort of came to a head. And I mean, I will say that we urged him to do that, just for the record. I said, you need to have that in your head and on the record that this is your biological daughter.
So you advised him to do that?
I mean, any number of people advised him to do that.
In 2016, you mentioned 2 visits that you were aware of face-to-face here. One was the birthday visit and one was the Christmas visit, correct?
Yes.
And you're aware that the parenting plan that was entered gave him additional time if he could come down here when he was off from his military duties, correct?
I didn't read the parenting plan. I'm gonna say, okay.
Well, you're aware that your son in military duties has certain days off around holidays like Easter, 4th of July, Thanksgiving, and all of these things.
Yes.
And the parenting plan gave him Thanksgiving specifically every other year and other days if he could come down here. But your son chose not to do that, correct?
Well, I wouldn't say that he chose not to do that.
But he didn't do that, did he?
Financially, I don't think he was able to do that.
He didn't do that, did he?
Financially, he was not able to do that. I think that he would have been glad to do that if Coley hadn't used all the money and left him sort of in a hole when they divorced.
So you think that's Coley's fault that he didn't come down here and visit with his child?
Well, I think that he didn't have a very good paying job. You know, the military doesn't pay a ton when you're a private.
And you mentioned the visits in 2016. One was the birthday and one was the Christmas. And you said that Coley wouldn't allow him to take the child, would only allow you all so much time with the child. Correct? Is that what your testimony was? Did you all file something with the court to say, hey, I'm not getting my rights, my parenting rights? He didn't file anything with the court, did he?
I think that Ben was still at that point concerned about someone had given him some pretty bad advice about how much it was going to cost to go to court. And as he was of, fairly low means at that point, he was busily saving up to go to court.
And my question was, he didn't file anything, did he?
And not to my knowledge.
And in 2017, the only visit he had was a Christmas visit, but he was here for Christmas, but he was sick the whole time. But he did manage to get with Cody Rainwater and do some things on that visit, didn't he?
He went to Cody Rainwater's the night before. Now, that wasn't the flu year. That was not the year of that he had the flu. So I may have my Christmas mixed up. There was the year that we saw Kinsley when Coley brought her over. Ben had not been feeling well that year either. He had a terrible cold. And so we did get some time with Kinsley that year. And then right before he left, he stopped over at Cody Rainwater's house. That's correct.
And in 2017, he didn't have any physical face-to-face visits with Kinsley, correct?
I have to really think about this, about these Christmases, which one was which one.
Well, you said 2017 was when he had the flu, and that was the only time he was in 2017, correct?
I believe so, yes.
Okay. And in 2018 is when you said you had the January visit and Coley cut you off from seeing Kinsley, correct?
Right.
So after that, from December of 17, when he didn't see Kinsley to when the petition was filed, there was no contact between Mr. Keel and Kinsley, correct?
Well, I'm going to assume not. I mean, she doesn't answer her phone or text. Ben texted her that Christmas when he was home and got no response, asking to see Kinsley, and called her, and I got no response.
Well, I asked in discovery for text to be brought forward with regard to times that he's requested to see the child and denied, and we haven't received any of those texts. I mean, do you have any text here today?
I have my phone in the car.
Well, the time for that would have been producing in discovery when I requested. We did receive one text from my client to Mr. Keel that he was able to produce after your January visit with the child. Do you remember your January visit with the child?
I do.
Okay. And that was at your dance studio.
Mhm.
And when Coley came and brought the child to visit with you, you took the child into another room, shut the door, shut the blinds, and was in that room alone with the child.
Now, her older daughter was in the studio with us,
Mm-hmm.
as were my two grandchildren,
Mm-hmm.
Chloe and Bradley.
Mm-hmm.
And as far as close the door, no, I wanted to. I said, can I have some time with Kinsley? She's here with the kids. And as far as the shade, I have a window that looks into the studio that has a rattan shade over it that you can see directly through.
Mm-hmm.
The door was never locked. She could walk through that door anytime she wanted to. But as it turned out, she would not let me close the door. And that's when she proceeded to tell me, you're not going to see her anymore. As long as you have her talk to Ben, show her pictures of him, or talk about him.
Now, we've introduced Ms. Coley Richards' phone records into evidence from July of 2017 through November 2017 through July of 2018. And would you be surprised that there are no phone calls from Mr. Keel to Ms. Pritchett during that period of time?
No, I wouldn't be. Why would he call when she doesn't answer? I mean, you know.
Well, it would reflect that he called and she didn't answer.
But what I'm saying is, from the very point where he found out about the affair, and of course he was upset and started the divorce proceedings and what have you, she was done. She wasn't going to cooperate. She wasn't going to answer the phone. She wasn't going to answer texts. She wasn't going to allow Kinsley to have her daddy in her life, so that if she could cut him out, then she could erase the affair in my mind. And that would be it.
And I asked Mr. Keel in his discovery to produce phone records from his side that would reflect that he was calling and she wasn't answering, and I received none of those phone records.
I don't know anything about it. I mean, you could have had whatever you wanted. You could come to my house. All the text messages, I say, just everything that I could.
Well, we introduced those into evidence, but we did ask for that during the pendency of this trial. In discovery that was sent to Mr. Keel, your son, back in 2019.
Well, he probably thought you were asking for his stuff.
Well, I did ask for his stuff, and he didn't present any of it to show that she prevented him from contacting the child.
Like I said, insanity is doing things and expecting a different result. And when you've called and contacted and, had contact through the grandmother and so on, and you get no response, your next thought is, we probably have to get this to a lawyer and a judge. And Ben was busy saving to get an attorney and take her to court. But I will say that as much as I talked to Ben about this, he always had hope that Coley was just going to come out of this, get over, whatever, the bad breakup and so on and so forth, and start being a real person and allowing him to see Kinsley like they had agreed to. He never dreamed that she would treat him like this.
So in 2016, when you say she didn't allow him to see him, he didn't file in 2016, correct?
Wait, go. I don't.
He didn't file in 2016 after the divorce.
That's the whole question.
He didn't file with this court to say she's not letting me see the child at any time in 2016 after the divorce in January of 2016, correct?
I mean, I don't think so. I think he was still saving for
In
it.
2017, he didn't file for the divorce, for contempt for her not allowing him to see the child in 2017, in those 12 months, correct?
Well, like I said, I think that he was thinking if he could get home and see her, maybe they could work this out and they wouldn't have to go through a court. I mean, Ben's feeling the whole time was, we were together. We had a child. Why can't we just work this out? Let's work this out.
But he didn't talk to her. He didn't call her. He didn't try to talk to her at all during those years, correct?
Yeah, he did. He called her and texted her when he was at home at Christmas and asked her, could he see the child? Then if he got no response, I would call her or I would text her and ask, can we see her? And it was always the same silence. Now, you know that she had a second phone.
But we don't have any text messages. He has not produced any text messages to support that claim, even though I asked him back in 2019 to do so, correct?
You asked him for text messages
Yeah.
from,
Him asking for visitation and her refusing.
We could stipulate that he has discovery.
I'm not sure how this witness would know that unless she was handling his litigation for him. I think you've made your point with Mr. already, so sustain the objection.
Do you have any text that would support that you were seeing this child every 2 weeks?
I have texts and I have time-stamped pictures. I always took pictures of her when I was with her. And then I sent them out to Ben as well.
Well, if Ms. Pritchett testifies it wasn't every 2 weeks, it was at once a month, sometimes once every 2 months. Do you dispute that?
I do dispute that.
But you don't
I'm
have-
sure there were periods of time when, again, Kinsley was sick, according to Coley, for periods of time. And I'm going to guess and say, well, she probably just didn't want to be bothered with me seeing her.
Do you have any text messages where you were trying to get visitation with Kinsley and she was refusing?
Absolutely.
But you don't have them here today.
I would have brought them had I known. Absolutely.
Well, you knew that you all's position today was that she was refusing visitation, but you were here today testifying, but you have no documentary proof, correct?
I was never asked for it. I would be glad to produce it. I have all of it, including timestamped pictures.
And when you would be out at the playground with Kinsley, what Coley was objecting to was you were chasing Kinsley around with the phone saying, talk to daddy, talk to daddy, talk to daddy.
So not true. I mean, how else would I have called her attention to come to the phone? Kinsley, daddy's on the phone.
And you weren't FaceTiming, it was just a phone call, correct?
I didn't have any video chatting at that time.
Would you be surprised if Kinsley thought in her mind, and she told her mom in her mind, she thought you were trying to get her to talk to your daddy?
Not sure I understand the question.
Kinsley does not know Mr. Keel as her father, does she?
I would say she probably doesn't, given how she was not ever allowed to spend time with him. I even gave Coley, at Ben's request, a 5x7 picture of Ben and asked her, framed, and asked her to put it in Kinsley's room so that when I was there, we could talk about daddy. And if I wasn't there, that she'd know who her daddy was and what his face looked like, along with me showing her on the phone and along with her talking to him on the phone. And she just laughed and said, yeah, sure, okay.
And the last time that Mr. Keel saw Kinsley face to face was at Miss Pritchett's house in December of 2018 when when people were in for court, correct? It was around Christmas.
Wait, when people were in for court?
You all had a court date in December of 2018 and he was in town for that and he asked Coley to be able to see the child and she allowed you all to come over to the house. Do you remember that?
I remember that he was in for Christmas. And we went over to see Kinsley. And if I'm not mistaken, we went to her grandparents' house. And if I'm not mistaken, she was sitting in timeout when we got there, which was, I'm sure, the punishment for seeing her dad, like Coley used to do to Callie when she was going to get to see Eric. She would always punish her before the visit. And this was something that was very upsetting to Ben.
And one of the reasons that he didn't make big confrontations in front of Kinsley, because he didn't want to get her punished. And I wonder too, if after the phone calls that we had, if she was punishing Kinsley.
That's all I have, Judge.
Redirect.
Gil, just for clarification, you had provided me with some text messages. Most of the difficulty you were having in arranging to see this child was back in 2015 during the parties' separation prior to their divorce, was it not?
Well, we did have problems back then.
Okay, but
Yeah.
throughout 2016 and 2017, she was allowing you to see the child
She was allowing me to see her,
up until she terminated that because of the contact you were allowing with Mr. Keel.
yes, but I will say not as often as I wanted to see her.
I understand. Okay, that's all I got.
Ms. Turner. Anything further?
No further, Your Honor.
Let me ask this question. If I'm understanding correctly, your son still lives in Virginia, is that correct?
Yes, sir.
Right. So how often is he coming home nowadays?
Well, I mean, he comes home for Christmas, and of course he came home for this hearing, but his situation is much different now. He's moved up in his rank with the military, so he has a little bit more, spending money to be able to come home. And he has a little bit extra leave because of what he does right now, because of what he's doing with the military. So he gets some extra time off because he travels a bit.
Thank you. You may step down.
Thank you.
Mathis, you may call your next witness.
Judge, that's our proof.
I'll hear you an argument. You have any rebuttal proof, Ms. Turner? I'm sorry.
No, Your Honor, we do not have any rebuttal proof, and with that, may I ask that the rest of her fans be able to come in?
They can come in.
Your Honor, in this case, these parties were divorced back in January of 2016, and at that time, Kinsley was 3 years old. There was a parenting plan entered that allowed Mr. Keel to come here on certain days of the year for Thanksgiving, certain holidays, Father's Day every year, Christmas, sometime every year, the child's birthday, sometime every year, and any other time, which we call Donza days, that he could be allowed to come down here and visit with the child. The proof has shown in that respect, Your Honor, since 2016, and this child was 3 years old, Mr. Keel has only come here in 2016 on 2 occasions, the birthday and the Christmas. In both of those occasions, he complained about his access to the child at that particular time, yet he filed nothing with the court to show the court that he was not being granted access. Also, Your Honor, we've introduced the phone records during that period of time that shows that Mr. Keel did not attempt to contact Ms. Pritchett during that period of time to talk to the child. I also ask in discovery that Mr. Keel provide me his phone records or any text messages during this period of time that would reflect that he was asking for visitation and that Ms. Pritchett was refusing visitation. And we have nothing here today before the court showing that. In 2017, Your Honor, there was not a birthday visit. He only came here in December of 2017, which time he said he had the flu. Nobody called my client to say he was in town and he had the flu and wouldn't be able to visit with the child. In fact, again, that we had the phone records, no phone calls during 2017 to Ms. Pritchett to try to talk to the child, to try to maintain a relationship with the child. He didn't exercise further in 2017 his court-ordered visitation, and we have no text messages. In 2018, from Christmas of 2017 through the petition was filed, that's the 4-month relevant period that the court must consider by statute. There is admissions that there was no contact with this child, nor any attempt to have contact with this child on the part of Mr. Keel. And again, nothing filed with the court saying, I'm not being allowed contact. I asked specifically for those things in discovery because I knew that they were presenting a defense that my client was trying to keep this child from Mr. Keel. And to do that, and for that defense to be successful, Your Honor, there would need to be proof. And it's not like this case has been pending since 2018. There's been ample time to get proof together for them to show to this court, I was trying, here's the text messages I was sending, here's my phone records where I was calling, and she was denying me visitation. On top of that, he wasn't exercising the court-ordered visitation that he was awarded in the final decree. On top of that, Your Honor, in the answer to this petition, he questions the paternity of this child. He didn't question the paternity of this child in the divorce. And, I might wonder if maybe that's why he wasn't necessarily visiting as much with this child during the 4-year period or the 2-year period from the time of the divorce until this petition was filed, 2 years and a couple of months. Now, you've heard conflicting testimony, Your Honor, from my client, Coley Pritchett, and Elizabeth Keel, the mother, as to how often the grandmother's visits were occurring. Ms. Coley Pritchett says they were happening approximately once a month or once every 2 months. Again, you hear Ms. Keel come in and say, I was asking all the time, and I was seeing the child every week, and I was texting her, and sometimes she wouldn't respond. And again, Your Honor, if it's not like this case has been pending for 4 months and we didn't do discovery. If that evidence was there, we would have it here today. So I would suggest to the court that the credibility of Ms. Pritchett is better than the credibility of Ms. Keel with regard to how often she was seeing the child. What is evident was that during those visitations, Ms. Keel was taking the phone and trying to get the child to talk to Mr. Keel on the phone.
Blame
No, I don't, Judge. But what I want the court to listen.
If he's not going to be a father to this child, wouldn't she want him to be a better father?
I would agree, Your Honor, and I would think that's probably why we're here today, is that more so the grandmother's part than it is with regard to Mr. Keel. And I don't say that to be crass. I say that because I think that's what the evidence bears out. But you heard Ms. Pritchett talk about the reaction that the child had to that. She didn't know who was on the phone. She does not know Mr. Keel as her father, and that was traumatic to the child. And that is why Ms. Pritchett asked her to stop doing that. So respectfully, Your Honor, I do believe the proof is replete that Mr. Keel has we've met the grounds of abandonment with regard to Mr. Keel's visitation, and we would ask the court terminate Mr. Keel's parental rights on the grounds of abandonment under TCA 36-1-113. With regard to best interest, Your Honor, we're operating under the statute that was in effect at the time this petition was filed, which is different than what the best interests are now. And I think that Ms. Massey correctly identified in her trial brief that she filed back when this case was originally set for trial, that those factors under the statute as it read at that point in time, the relevant factors are 1, 3, 4, and 5. 1 being whether the parent or guardian has made such an adjustment in circumstance, conduct, or conditions as to make it safe or in the child's best interest to be in the home of that parent. Respectfully, Your Honor, I don't think that Mr. Keel has done that. He has not maintained significant contact with this child, and it is not in the child's best interest to visit with him at this particular time. It is in the child's best interest to sever ties with Mr. Keel at this point in time. Factor number 3, whether the parent or guardian has maintained regular visitation or other contact with the child. And again, Your Honor, I think the evidence is replete that Mr. Keel has not done that. Number 4, whether a meaningful relationship has otherwise been established between the parent or guardian and the child. And I do not believe, as we sit here today, that anybody has testified that this child knows Mr. Keel as her father. She knows Mr. Pritchett as her father. And it is in her best interest that Mr. Keel's parental rights be severed and that Mr. Pritchett be allowed to establish the legal relationship of father and daughter. And number 5, the effect of the change of caretakers and physical environment is likely to have on the child's emotional, psychological, and medical condition. It's in this child's best interest that we establish the parent-child relationship between Mr. Pritchett, who she believes to be her father, and this child, and sever Mr. Keel's parental ties. Thank you.
Mathis?
Your Honor,
The court's well aware the threshold question is whether or not a ground to terminate Mr. Keel's rights exists in this case. And as stated in the petition that was filed back on April 23rd of 2018, only one ground was alleged, that ground being abandonment. Abandonment being defined as the respondent having willfully failed to visit or support for at least 4 consecutive months immediately preceding the filing of the petition. The court's well aware. So the relevant time period for the court to look at to determine whether or not that ground exists is December 23rd of 2017 through the filing on April 23rd of 2018. It's undisputed during that time that he was current on his support. So the or support component of that ground, they fail. With regard to the willful failure to visit, the proof before the court is that he had consistently visited with this child during Christmas vacations and on Christmas Day, I believe, was the specific testimony, prior to 2017. And that during that visit, he was so sick that he couldn't hardly get out of the bed even to go home to Virginia at the end of his time here in Tennessee. The mother testified that if he had been well and had asked her, he would have been allowed to see the child. That's not a willful failure to have visited for Christmas. That's a physical inability to do so.
The statute also talks about more than just token visitation. Your client's testimony was that he visited with the child 30 to 45 minutes on birthday and Christmas, and that was 2 times a year. Would you consider that to be token?
In a vacuum, those 2 in-person visits alone, I think the court would find that to be token visitation. But I think the court has to look at the totality of the circumstances for each family in each particular situation when it's faced with these types of cases. And this particular family's course of habit had been for him to telephonically visit with this child regularly. At best, if we take what he said, weekly. If we take what Ms. Keel said, bi-weekly. And at worst, if we take what Ms. Pritchard said, monthly. He was interacting with this child on the telephone for one of those durations. I don't know that anybody wasn't telling the court the truth. The trajectory of this case has caused us to have to ask these people about things that at this point happened years ago. I don't necessarily remember whether or not I was doing something once a week or once every other week back in 2017. So I'm not going to accuse any of them of lying. But again, at worst, we're talking about monthly interaction with the child. And the proof to the court was that he lived in another state and that he was financially challenged in terms of when he could come home to visit. But it appears that during every instance that he did come home to visit, he made efforts to see this child. And the mother admitted that she, to some extent, thwarted those efforts. She said she would not let him take the child alone or have the child alone. And she was very clear that she eventually severed the contact with the grandmother because the grandmother was allowing interaction with the father. It's our position that the facts of this case are such that the court should not find that Mr. Keel had abandoned this child, and therefore the petition cannot survive the first prong of the 2-prong test.
Anything further, Ms. Turner?
Just as to Mr. Mathis's comments
About taking the totality of the circumstances, that's why we put in the phone records to show that Mr. Keel, if he was wanting to make an effort, should have been calling, texting, doing something that would show that my client was thwarting that visitation.
This is a case that is not an easy decision for the court, but I know that this has been pending for some 5 years, and so there needs to be some resolution to it. So I am going to take a lunch recess, and there's some case law I want to look at that I think may be applicable, and I will hopefully be able to come back probably around 1 to 1:30 sometime. If you will just be back here at the courthouse around a little after 1, then I'll hopefully be able to give you my decision. So in the meantime, we will stand in recess for lunch. All right. I apologize. We're back on the record. Mr. Riggins is so adept at being quiet in the courtroom that I forget about him being the guardian ad litem. So I wanted on the record, since we're recording this under the proceeding, we don't have a court reporter, but we are making a record. Ms. Riggins, as the guardian ad litem, I failed, and I apologize, I failed to ask you for your input in it. If you would go to the podium and just let me hear whether there's anything you want to add to this.
Judge, first of all, I think both attorneys have done great and been thorough, so there's very little that I could even flesh out. I just wanted the court to recognize that I'd filed a report with this court. I just wanted to verbally update that report since it had been almost 3 years. The minor child and the mother had relocated, and I did go back and check into that home and view the child and speak with both the petitioners. I just wanted to let the court know everything's appropriate there, everything's safe, and everything looked healthy. That was the only thing I wanted to make the court aware of, was just to update that report.
All right. With that then updating, we will now stand at recess for lunch.
All right.
All right. Appreciate your cooperation and giving me time to make sure of what I'm trying to do in this case and make sure that I'm comfortable with the decision I make. Unfortunately, I'm not. I've often said, those lawyers who practice in front of me on a regular basis know that one of my favorite things that I get to do in this job is to grant adoption. Most of the time when I'm happy to grant an adoption, it's simply because of the fact that one of the parties are by agreement taking a child into the home and taking care of that child and raising that child and providing for the child that would not otherwise have that opportunity. So in this kind of situation we're in now, it presents almost an impossible dilemma or an impossible decision for the court. But since I'm required by my oath to make those decisions, I will do my best to explain what my rationale and thinking is. First and foremost, as the lawyers know, and it's been brought out, the termination of parental rights is a two-part test. The first test is the first stage is that the petitioner must prove grounds exist, and there are two grounds that could be alleged in this situation, several grounds that could be alleged, but in this particular situation, the abandonment is the grounds. There are two basic types of abandonment under our state law, and one of them is failure to provide support for a minor child for a period of four months prior to the filing of the petition. The second is failure to exercise visitation other than nominal or token visitation. And there's plenty of case law about what is a token visitation, and I'll touch on that in a minute. But token visitation does not excuse abandonment. It can still take place. So that's the law in the state of Tennessee. 4-month period, as Mr. Mathis pointed out, operating in this case goes from 2017 to 2018 when this case was filed. And the court has to make a finding that there's been clear and convincing evidence that the father has abandoned the child on one of those grounds. Clearly, the evidence in this case shows Mr. Keel had paid his child support regularly, but the evidence also shows that he failed to exercise any visitation with the child, speak of, other than perhaps token visitation, actually for almost the entire time since the divorce in 2016. But the court has to determine whether or not that is willful or not. And while he makes the argument he could not afford to make that visitation happen, and that he did have alternate means of visiting with the child, still is, in my opinion, the proof has risen to the level of clear and convincing proof that the father has in fact failed to visit with the child for a period of more than 4 months prior to the filing of the petition. Now, his efforts to visit with the child after that are not pertinent on the issue because you cannot repent of an abandonment. Once you've alleged to abandon your child, what you do after the petition is filed cannot undo what has taken place before. So, in one respect, they've proven their grounds to petition on the petition to terminate your parental rights. The second part of that test is the most difficult part for this court, whereas the evidence is pretty clear about your lack of visitation with the child. The more difficult part of this case is what is in the child's best interest. That's the second part, and I can only terminate parental rights when I find that the termination is actually in the best interest of the minor child. In determining what is in the best interest of the child and whether termination is in the best interest of the child, I'm required to go by the statutory factors that are set forth. While Ms. Massey, when she represented the petitioner in this case, cited some of those in her pretrial brief back years ago, there's been a 2021 amendment, 2021 amendment to the adoption statute, and it's still located under 36.1.113 subsection I, but there's a whole new set of factors. And I'm going to go through those on the record so that we can understand what my thinking and belief is. The first one is, and they instead of numbering these, they go by A, B, C, D. So this first one is A, the effective termination of parental rights. And here, let me read this part. In determining whether termination of parental rights or guardianship rights is in the best interest of the child, the court shall consider all relevant and child-centered factors applicable to the particular case before the court. Those factors may include, but are not limited to, the following. A, the effect of termination of parental rights will have on the child's critical need for stability and continuity of placement throughout the child's minority. In that situation, it would seem to me that by terminating parental rights, that I'm allowing the child to have stability and continuity of placement in the Pritchett home. And it would eliminate the need for visitation with the father and having to go back and forth and so forth. So that's a factor that would probably favor the petitioner. The effect of the change of caretakers and physical environment is likely to have on the child's emotional, psychological, and medical condition. There's no evidence before me of any emotional, psychological, or medical condition that would be affected by this. So I do not find that to be an applicable factor. C, whether the parent has demonstrated continuity and stability in meeting the child's basic material, educational, housing, and safety needs. Clearly, Mr. Keel has not, at this point in time, been actively involved in the child's life other than paying his child support regularly, which in that respect could be construed to say that he has met his obligation to help provide basic material needs of the child. Subsection D, whether the parent and child have a secure and healthy parental attachment, and it's not whether there is a reasonable expectation that the parent can create such an attachment. In this case, the evidence has been that this child doesn't know who Mr. Keel is. As a result of that, I cannot say that that he and the child have a healthy and secure parental attachment, I think. But I don't have any proof to say that there's not a reasonable expectation that under the different circumstances that Mr. Keel could not create such an attachment. So I found that to be neutral. I don't find that it favors either termination or non-termination. Subsection E, whether the parent has maintained regular visitation or other contact with the child and used the visitation or other contact to cultivate a positive relationship with the child. This is a problem for this court because while I don't think you can say going to a birthday party for 30, 45 minutes, coming back for Christmas and having a very brief contact would be regular visitation. Obviously, that was the grounds upon which I found they had proven the grounds they just to terminate. So I don't think that that can be applied beyond that because it's a factor that was used in finding grounds. But under the circumstances, I have no reason to believe there's not a good positive relationship that he's attempting to create. I just find that he has not maintained regular visitation. Now, Mr. Keel argues that Ms. Pritchett has prevented him from having regular visitation because she won't let him take the child away. But from a mother's perspective, you've got an individual who's really not been much in the child's life since 2016, then in 2017, a year later, without really any contact. I can understand why she might not be very comfortable with letting you take this child away from her. Mothers are very protective by nature. Sometimes that works to the advantage of the child. Sometimes it becomes a little bit more difficult. There's a popular terminology of a helicopter parent, and I've heard that term before, and that means someone who hovers so much over the children that creates problems for the children. So don't understand that Ms. Pritchett's desire to protect her daughter and maybe prevent you from taking the child away when you haven't seen the child in so long is necessarily some, reason that she's trying to destroy your relationship. She's probably more, at least in my opinion, from my observation over here in the courtroom, more inclined to try to protect the child. Number F, whether the child is fearful of living in a parent's home. There's no evidence that this child is fearful of Mr. Thiel. G, whether the parents or parent's home or others in the parent's household trigger or exacerbate the child's experience or trauma and post-traumatic symptoms does not apply. H, whether the child has created a healthy parental attachment with another person or persons in the absence of the parent. And I do find that she has a healthy relationship with Mr. Pritchett and views him as her father. I, whether the child has an emotional significant relationships with persons other than the parents and caregivers, including biological or foster siblings, likely impact of various available outcomes on those relationships and the child's access to information about the child's heritage. Now, this one plays into Mrs. Peel with the grandmother. I heard all my life that being a grandparent's a wonderful thing. I always thought it was kind of, I've raised children, two of my own, two stepchildren. I always thought grandparents, well, I had my parents and they became grandparents. There's an old movie with Paul Newman in it where he and his son were estranged, and son shows back up years later and he's got a son, and Paul Newman becomes a really good grandfather. He says, and his son says him one day, he says, "How is it you're such a great grandfather when you were such a lousy father?" So things change a little bit when you're a grandparent. Mrs. Keel is a grandmother. She loves her son. She wants her son to have a relationship with his child. And so she acts in that regard. There's nothing wrong with that. Obviously, you have to balance that with a mother's right to be sure that of what's going on with their child. This factor, clearly, in my opinion, the child has a relationship with Mrs. Keel as a grandmother. And I find that this factor would favor, or rather would mitigate against the termination simply because it would just prevent this child from being a part of the Keel family from that point forward. So I think that factor would favor the non-termination parental rights. Number J, whether a parent has demonstrated the lasting adjustment of circumstances, conduct, or conditions to make it safe and beneficial for the child to be in the home of the parent, including considerations of whether there is criminal activity. There's no evidence of that, alcohol, controlled substance, or any such thing as that. So it really doesn't apply in this case. Whether the parent has taken advantage of available programs, services, and community resources is not applicable. According L, whether the department has made reasonable efforts to assist doesn't apply. Number M, I want you to listen to this, Mr. Keel. Whether the parent has demonstrated a sense of urgency in establishing paternity of the child, seeking custody of the child, or addressing the circumstance, conduct, or coincidence or conditions that made an award of custody unsafe and not in the child's best interest. That really doesn't apply because you're not seeking custody. But it does apply in this court's mind. If I had a child and I was not being allowed, I would crawl across broken glass for miles to see my child. I don't understand the logic of someone who has not made more of an effort to try to see the child. But by the same token, I've not been in your situation. And I understand that you are in the military, and as a result of that, there are limitations upon you that we who are civilians do not have those limitations. You answer to your commanding officer, and you are required to do what you're told to do. You don't have the freedom and luxury to come and go as you please. And I consider that and credit that to you for serving your country in that way. but you're going to have a little bit of a different attitude, in my opinion, more of a sense of urgency, it seems to me. Whether the parent, or this is subsection N, whether the parent or person residing with or frequenting the home has shown brutality, none of that. Whether the parents have provided safe and stable care for the child or any other child. I don't really have any evidence about what took place prior to their divorce, but under the circumstances, he certainly has not provided care for the child up to this point. Whether the parent has demonstrated understanding of the basic and specific needs required for the child to thrive. Again, I don't have any evidence about that one way or the other. Whether the parent has demonstrated ability and commitment to creating and maintaining a home that meets the child's basic and specific needs in which the child thrives. I don't have any evidence to show what your home is like in Virginia. Whether the physical environment of your home is healthy, safe for the child. Again, I don't have any evidence on that. Whether the parent has consistently provided more than token financial support for the child. You have supplied support according to the final decree, and that's to your credit. Whether the mental or emotional fitness of the parent would be detrimental to the child or prevent the parent from consistently and effectively providing safe and stable care and supervision for the child. Have nothing to indicate that you have any mental or emotional problems. So there are a lot of other factors, there are other considerations, but those are the factors that I'm required to do that. So this court is now faced with a difficult decision of trying to determine whether or not the factors that I've just gone over and the evidence in this case would justify termination of your parental rights. And so I'm faced with an impossible decision. If I terminate the father's rights, then the child will carry on in a stable home with a stepfather who becomes, in legal terms, the father that he really already is by default. And she will really never know her biological father beyond that point or her biological father's family. In this court's mind, I would have to question the effect that this is going to have on this child as she becomes older and the effect on her relationship with her mother to know as she gets older that her father wanted to have a relationship with her and wanted to try to develop a better relationship with her, but the mother prevented that and terminated his parental rights. I think that could have a detrimental effect on your relationship with your daughter as she becomes a teenager or into adulthood. And I say that based on my experience in numerous cases, whereas children who had suffered parental alienation during a divorce, and I'm not saying that's what's taking place at all. I know you're acting on behalf of your child and what you think is best for your child, but there are many cases in which children grow up and they realize that they have been alienated from the other parent by the custodial parent, and that creates an insurmountable chasm between them and that custodial parent as they grow older and realize that they could have had a relationship with their other parent. So I don't know. If I terminate the parental rights, she'll really never know that part of her biological or extended family either, as I explained about Ms. Keel. There is no proof in this record of any expert testimony that there will be any adverse effects psychologically, emotionally, or on Kinsley if I do not terminate the parental rights, or that if I terminate them, there will be any effect. On the opposite consideration, if I do not terminate his parental rights, I must ask, am I condemning this child to be in a state of constant emotional turmoil caused by a father who is absent, who's content to see her 2 times a year, despite having opportunities to do that? I told you what my attitude would be if it were my child, and what I'd do to try to go and see that child. That's just me. Obviously, you're not me. So it boils down to this. There is no proof that the respondent can't be a good father or can't be a good influence on this child if he's given the chance and if he takes the opportunity to exercise that. If I decline to terminate his rights, Kinsley will have the chance to know that her father, as she grows up, and to know his extended family and her extended family by extension. She'll also have Mr. Pritchett in her family and in her life, and he will be the father figure by default that he's already been. So he will continue in that role It won't change anything between the two of them. Being a step parent's hard. I know that firsthand. You've obviously done a great job and you're willing to step in and be the legal father. Changing the legal father from Mr. Keel to Mr. Pritchett does not change or declining to change it, does not change the relationship between Kingsley and Mr. Pritchett. That can still continue. What it does do by terminating his rights is eliminate Kingsley's opportunity to have a relationship with her father. Based upon that consideration and the fact that there is no evidence of any danger or harm to this child from continuing the parent-child relationship. This is most of the time in these termination of parental rights, we have drug use, we have abuse, we have other factors that lead us to believe that it's manifestly in the child's best interest to terminate parental rights. But none of that is here. What we have is someone who has failed to be present, and it may develop, may cause some emotional upheaval to the child. You know, if you continue that and you don't see this child, if I continue your parental rights, then you have to think about what you're saying to that child. But my finding is that based upon the lack of any proof of harm or danger to this child, that the opportunity with time to develop a relationship with her father, continuity of stability in the Pritchett home, and the fact that by making this ruling, she may continue her close relationship with her stepfather, then I think that those are factors that weigh in my decision. And I also am compelled to look at the case law, which I spent the lunch hour doing. And I would point out that I'm relying largely on a case called N. Ray Archer R. It's 2020, decided February the 19th of 2020 by the Court of Appeals. Judge Andy Bennett authored the decision in that case. Judge Katie Klinghardt was one of the attorneys, and Taylor Dahl was the other attorney. In any event, not that that matters, but these lawyers know them in particular. And in that case, what it was is essentially that they alleged that the father had abandoned the child by failing to visit, failing to pay child support. The trial court found that the proof was he had not visited the child, but that his allegations that the mother prevented that visitation from taking place meant that it was not a willful abandonment of the child because of the simple fact that she had prevented it. And the Court of Appeals agreed. The visitation is visitation of the circumstance of an individual case. It constitutes nothing more than perfunctory visitation or visitation of such an infrequent nature or such short duration as merely establish minimal or insubstantial contact with the child. It sounds familiar, doesn't it, Mr. Keel? But they go on to talk about failure to visit or support a child is willful when a person is aware of their duty to visit or support, has the capacity to do so, but makes no attempt to do so, and has no justifiable excuse for not doing so. Failure to visit or to support is not excused by another person's conduct unless the conduct actually prevents the person with the obligation for performing his or her duty or amounts to a significant restraint or an interference with the parent's efforts to support or develop a relationship with the child. When a parent, and I'm skipping over to another quotation, when a parent attempts to visit his child is thwarted by the acts of the others, the failure to visit is not willful. That's saying they have a 2016 Court of Appeals decision there. In that case, they found that the proof did establish that his efforts, the father's efforts in that case to visit his child, had been thwarted by the mother and her new husband who was seeking to adopt. And the Court of Appeals went on to find that clear and convincing evidence in that case did establish that grounds had been proven just as here to terminate to find that the father had abandoned his child, but in that case by failing to pay child support. So they went on then and looked at the factors. And the judge at that point made a ruling that, in his opinion, it was not in the child's best interest to terminate parental rights, even despite the fact that he had failed to support the child. Court of Appeals said, when considering the statutory factors, courts must remember that the child's best interests are viewed from the child's rather than the parent's perspective. And that's hard sometimes to understand. Child's interests diverge once the parents and child's interests diverge once grounds for termination has been proven by clear and convincing evidence. When the best interests of the child and those of the adults are in conflict, such conflict shall always be resolved to favor the rights and best interests of the child. Facts relevant to the child's best interest need only be established by preponderance of the evidence. Although the petitioner may establish that the combined weight must establish that the combined weight of the proven facts amounts to clear and convincing evidence that termination is in the child's best interest. Goes on to talk about the factors that are there. And the court in that found the following: it is not in the best interest of the minor child to terminate father's parental rights. This is something that affects the minor child for the rest of his life, including his adult life, not to have a parent. The minor child should have both of his parents. The minor child has a sister who the minor child should know. The minor child has a grandmother, father's mother, and the minor child should know her and the rest of the father's family. It's better to have more people to love and care for the minor child rather than fewer people. There's nothing wrong with a minor child having two dads, both the father and the stepfather. Court of Civil Appeals considered all of that information and affirmed that it was in the best interest of the child not to terminate parental rights. I think that is a case that is instructed to this court, and for the reasons that I've stated, I found that it is not in the best interest of this child to terminate Mr. Kill's parental rights. But Mr. Kill, it is now incumbent upon you to demonstrate whether or not you have the capacity and the desire to be a father to your daughter. And I've said this on more than one occasion, usually in the form of an adoption by someone who has taken a child in. It takes more than biology to be a parent. And so far, one of our other judges used to say this. I'm not saying that because I'm not terminating your parental rights, but I am going to tell you that you're borderline very close to what Judge Alan Wallace used to always say. And he said it to some of my clients years ago in this very courtroom. And that is, if you were on trial for being a father, there wouldn't be enough evidence to convict you. Now, that's not true in your case because you've been paying child support and you've made some efforts to visit your child. But visiting your daughter 2 times a year, even if you talk to her on the phone, is not sufficient. And that, in my opinion, is the reason that I found that you had abandoned your child. They had met the threshold of that. I'm finding that your daughter deserves to have an opportunity, not that you deserve it, but that your daughter deserves to have an opportunity to have you in her life. And it's for that reason and that reason only, based on all those factors that I've gone over and the decision that I've cited, that I'm not terminating your rights. That doesn't mean that if you go about now having made all of these findings and made this ruling, that you continue down the same path, then there's nothing that would prevent them from coming back in and saying, that you have demonstrated a complete willingness to not have a relationship with the child, and then it will be cleared and convinced that your rights should be terminated. Do you understand that? If you don't like how this is drawn up, then you can hire a lawyer. Mr. Mathis is a very good lawyer, appears in front of me on a regular basis. And you can try to get something done that will give you a regular visitation. But you cannot just sit back and do nothing and expect that you're going to have a relationship, or that Ms. Pritchard is going to want to just send her daughter off with a guy who hadn't seen her in a year and a half or 2 years. I don't blame her at all for that. I do believe that Ms. Pritchard was justified in bringing this action based upon these things. These are not easy decisions, and Mr. and Ms. Pritchard, I want you to understand. I understand the basis and I understand your logic and the reasons for wanting to do this. And there's very much a part of me that would like very much to do that. But I feel that if I did that, the Court of Appeals would probably say that I made the wrong decision based on these things. For that reason, I'm doing what I think is the best thing right now for your daughter. That may change down the road. But in any event, I hope everyone understands my ruling. Ms. Turner, I'm going to ask Mr. Mathis to draw the order since it's.
I had just one question. The reason I didn't argue the new statute was because I understood that the new statute dealt with petitions that were filed after that statute came into effect as of April of 2021. That's,
They're essentially the same things that you cited are in the new statute versus the old, except for the language has changed around a little bit.
a lot more child-centered than the old statute, and that's why I just wanted to put
I don't
that.
have a problem with that, and I assume that may be the case, but in my opinion, it's instructive to this court on those factors and interests.
Thank you.
Court stands adjourned.
All right.